Go ahead.
Thank you, sir. Good afternoon. On behalf of the faculty, management, the students, and the entire Manikchand Pahade Law College of Aurangabad, I, Lokesh Kansal, extend a warm welcome to one and all for our 1 week online lecture series on environmental law. For the first session of the series, for the topic Forest Laws in India, we have with us as a resource person, respected Dr. K. Sudha, Assistant Professor, Damodaram Sanjeevya National Law University. Progressing into session, I request our Vice Principal, S.N. Moore sir, to give the welcome address.
Thank you very much. First of all, I take this opportunity to welcome all the dignitaries in this 1 week online lecture series on environmental law, which is to be conducted from today to 6 February 2021. Dear participant, in this lecture series, we are going to have a deliberation on the topics like follows: forest laws in India, public participation in environmental impact assessment, wildlife and climate change, biodiversity and international perspective, contemporary national and international challenges of environmental pollution, National Green Tribunal practice and procedure. And we'll have the resource persons like Dr. Sudha ma'am, Dr. Madhuri Parik ma'am, Srimati Vidya Jacob ma'am, Dr. Rajalakshmi ma'am, Dr. P.P. Wagmare sir, and Advocate Saurabh Kulkarni from different places of the country, representing their reputed and esteemed institutions. I am very happy to welcome you all in this first session, which is to be conducted by Dr. Sudha ma'am, Assistant Professor, DSNLU, Visakhapatnam. The very important issue she is going to deal with us, forest laws in India. What I believe is that many issues relating to this forest are we are facing about the rights of the forest dwellers, tribals, and wildlife, particularly in the matters of land acquisition. And I also believe that some of the issues may be settled according to the provisions of the 2013 Act, which is speaking about the right to fair compensation, rehabilitation, resettlement, and land acquisition. I hope and I am sure that in the today's lecture, our resource person, respected Dr. Sudha ma'am, is going to guide us on such kind of the many issues and laws in India which are there for protection of the forest and the rights of the forest dwellers, particularly those communities who are going to hamper their rights while executing those kind of the laws. Again, I will not take your much of the time, and I will take this opportunity to welcome you, ma'am, and all the participants who are participating from different esteemed institutions of the country. Thank you very much.
Thank you, sir. I take honor in introducing respected Sudha ma'am. Ma'am is an assistant professor at Damodaram Sanjeevya National Law University. She has 21 years of teaching experience, was a part of 2 research projects, and a practicing advocate for 5 years. Though her specialization in her master's was constitutional and administrative law, she was associated with family laws for a long spell. She is teaching environmental law and administrative law for the past 5 years. She is also the General Secretary of Human Rights Forum, an Andhra Pradesh based human rights organization, and associated with the human rights movement for the past 3 decades. She has penned a few articles and case comments in English and Telugu. Her book titled Prostitution Laws and Enigma and Some Dilemmas was published by Promila and Bibliophile South Asia, a Delhi based publishing house. She has also edited a book titled Green Governance, published by Asia Law House and DSNLU. We have a very esteemed resource person with us today to cover the topic forest laws in India. Before ma'am presides with her address, there is a notice for attendees. We understand that you may have certain questions and queries for which we have reserved some time post our resource person's address. YouTube attendees, post your questions in the comment box or the chat section in the updated YouTube. Those on Zoom, please keep your audio on mute for immaculate progress of the event. For your queries and questions, please post them in the chat section. Over to you, ma'am.
Thank you, Lokesh. Um, I deem it a privilege, and I feel honored that MP Law College has invited me for the 7-day lecture series on environmental law, and I congratulate the MP Law College and personally Dr. C.M. Rao and Dr. Aparna for organizing this grand event. And let me get into the topic which has been assigned to me, and that is forest land laws in India. I'm just wondering, there are so many entry points whenever we speak about any topic, several entry points. I just was wondering where I should begin. Should I start it with the Rio conference, the Earth Summit of 1992? Because all laws ultimately we draw a lot of inspiration, and many initiatives have come from the international uh, uh, community, which has made us sit back and think where our lives are leading towards. So if you talk about the Earth Summit, there were a few things which happened there in the Earth Summit in 1992, the Rio conference, where they wanted to have a Earth code, a kind of an Earth code, the way we have the UDHR. They wanted to have an Earth code, but somehow that could not materialize because the world was not prepared, and we, the global citizens or our leaders, were not prepared to have a Earth code the way we have the Universal Declaration of Human Rights. So, as a piecemeal exercise, we had certain kind of the world leaders agreed upon a few things, and one of them is that they could iron out their differences, and they could come up with the UN framework on climate change, and the Convention on the Biological Diversity, and the third one on desertification, a convention against desertification. These were the things that they could agree upon. But when it came to the forests and forest resources, they could not arrive at a conclusion because the developing countries had their own premonitions, their own apprehensions about whether they should agree with this and go ahead with this or not. So at the most, what Rio conference could achieve was that they came up with the forest principles, and the forest principles are non-binding in nature. Now, this is the story when we speak about what happened in the international um, um, in international law. That is where we stand in terms of forests. Then, when you speak about conservation of forest and environment, the initiatives come from different parts. One of it is the international community, and from within the country itself, we find that several initiatives take place, and we speak about conservation of forest. But when we speak about conservation of forests, we don't, there are myriad voices. So many different approaches are there. And broadly, we can divide those or classify those perspectives or approaches into broadly two categories. One is those who are pure conservationists, who believe that the forest should be conserved, and that is one approach. Then the second one is where they put the human beings in the center, the anthropocentric approach. In that, we are concerned about the forest, but at the same time, the human interest is what is central to everything. Broadly, this is the classification, but even within conservationists and those who speak about anthropocentric approach towards forests, there are again differences of opinion. And I think when we speak about forest and forest laws, all the forest laws that have been passed have some way or the other are a reflection of all these different perspectives which prevail in the society. And we find that at one particular given point of time, there is one particular approach is appreciated, and the laws which are passed in that particular period will be reflecting that approach. Then again, there will be it's like a perpendicular. Sometimes we go to one extreme and sometimes we go to another extreme. And I think India has witnessed this kind of extreme ways of looking at it, and even at times moderate people are moderate and try to think about what can be done in the best interest of conservation of forest and in the conservation of wildlife, and at the same time taking human beings interest in view. So let's keep this in mind when we speak about the issues related to forest laws, that there are different perspectives. And there is nothing wrong in having differences of opinion in a society, because that is how this whole churning, Sagara Madana, in this whole process, it will be a learning experience, and finally something good will come out of it. That is one aspect. Then the third thing that I would like to state before going into all the details, into the details of the forest laws, where we stand, and what are the latest development in this area. I think the fundamental thing that we have to remember, and the question that we have to ask ourselves is, who owns the forest? Because I think that is where the problem lies with that question, and also a solution is also lies with the asking ourselves, who is the owner of the forest? And with this note, I would like to start my lecture, and I would like to share my this PPT presentation which I wanted to share. I'd like to wait a minute. I'm just figuring out. Is it visible?
Yes, ma'am.
Look, yeah. Here, wait a minute. It's a long time since I prepared this particular PPTs. Forest, when we speak about forests, generally we have a few what notions, and maybe we have when we pass through a forest area, when we are traveling, we notice that it is full of flora and fauna, and there are different aspects in which how we encounter or we come across forests, how we think about forests. One thing that we understand is that we only think that their wildlife is present there, but we hardly realize that there are a set of human beings who stay and who reside in the forest. And sometimes they reside in those forests, and there are certain forest villages also. And they might be villages which are forest which villages which are have actually entered the people have conducted a survey. The Forest Survey of India might have conducted a survey, and it might be a notified forest village for forest village, or not even a notified forest village. So apart from elephants, tigers, deers, and different kinds of flora and fauna, even there are certain set of human beings whose natural habitat is the forest itself. And who are these people? Basically, they are the Adivasis, and there are other non-tribal communities also who are known as traditional forest dwellers. This is when we look into this particular aspect. The second thing that we have to see is that what is the forest cover of India as such. I just picked it up. This is what we I picked up these maps which are what dated 2011 and 2015 also later, where we speak about what the forest cover. So all these forest region which is covered is hardly 21.67% as per 2019 Forest Survey of India's report. It is somewhere around 21.67, and our target is that we have to achieve the forest cover should be at least 33%. There is an increase in the forest cover compared to 1980s, because constantly we are striving to improve the situation, and a lot of efforts are being put in to address the issue of deforestation. And social forestry is one thing that we are pushing for on a large scale, and that those efforts are paying to a large extent. So we find that there is a slight increase in the forest cover, but not as much as we really would like to have. So 33% is the target. We are lagging behind in that particular aspect. That is in terms of forest cover. Then how did it? Then the other thing that I was referring to earlier was who owns the forest. And why do we have to be specific about this particular aspect? Is that it makes a lot of difference. Suppose our participation in the Rio Conference 1992 and other developing countries' participation in the Rio Conference 1992, we were very particular that if we agree and are a part of the convention, then we will be losing our sovereignty over our natural resources. How we have to use our natural resources. Some external force will be deciding the fact how we have to expend or how we have to utilize our natural resources. And all the developing countries were dead against it, because again, they will be losing their say over the use or utility of their forest resources. That is one thing. That shows that takes us to which part of the whole problem. How we look at the natural resources and how do we look at the forest as such. Uh, Forest is a area which is again a rich source of where we get all the minerals. So it is a place where we get our coal, our iron ore, our copper, different mineral sources are there in the forest area. Look at the forest cover that I was speaking of earlier. The area which is under what the forest region, if you look at it, is the central India, and that is Madhya Pradesh, then parts of Bihar, Jharkhand, especially Jharkhand, Orissa, parts of the northern parts of Andhra, AP, and Telangana is the central part, which is known as the Bastar region. We have a lot of forest cover. Then if you go to the northeastern parts, you find that there again there is a thick forest cover. And then again in the Himalayas, you find another cover. And again, western Ghats, you find there is another stretch of green. And the central part of India, and that is the Bastar region. Maybe Bastar may not be an area where we'll find iron ore, but Jharkhand and parts of Orissa, parts of AP, we find a lot of mineral resources which are there in the forest region. So if that is the case, how is that natural resources supposed to be tapped? That is a major problem that we come. So there is intrinsically there is a kind of a contradiction between what the fact that we have to conserve the forest at one level, and the second thing that is there is that we have to again extract all those mineral resources, because without mineral resources, without actually tapping all those sources, we cannot either get industrialized, or in terms of economic development, it might be used for export for the to export that iron ore, and in terms of trade and commerce, again, extraction of mineral resources is something which is very, very important. So that intrinsically there is that contradiction is there. That is why I come back to the question, who is the owner of the property of that forest resources? That will take us to the history of India, and how actually in the past, how the forests were considered, whether they belong to the people of India or whether they belong to the rulers of this country, and who own that those forest resources. That we have to look into the little bit. I'll just take you through very, very quickly, and then bring the whole discussion on the present enactments as soon as possible. Please, if you feel that there is any kind of a clarification that I have to give, please raise that issue as soon as possible. I'd respond immediately. Then when you speak about this history part, I'm taking you through this history because, again, one thing, it is interesting. Then all the problems or which are there in the present are somewhere or the other, they are a reflection of the past. So to find the answers for today's problems, I think we have to look at a few things which happened in history. Now, when we speak about civilization and our first steps towards trying to lead a life where when civilizations actually started in the subcontinent was a home for different civilizations, and especially the ancient civilization Harappa and Mohenjo-daro. They were established on the banks of Indus. Now, this is an interesting point that I would like to present, and that is D.D. Kosambi, an Indologist, opinion and his observation about actually about the Gangetic plains. Now, D.D. Kosambi is from Maharashtra. I don't know whether you're familiar. He must be a very, very tall figure in Maharashtra, and the SNDT University. Professor Meera Kosambi happens to be his daughter, one of the founders of SNDT University. Kosambi, as I had said, is a tall figure in Indian academia. He has had observed that when they had this whole Harappa and Mohenjo-daro were established, they had actually the soil in that particular, on the banks of Indus, is very, very loose. So the construction of the cities was, for that they did not have to use too sharp instruments. But when he gives an inference, he draws an inference that but when it comes to migrating to the Gangetic plains much later, And when people started settling down, the Aryans started settling down in the Gangetic plains, the soil there was very, very hard. And they had to use certain kinds of sharp instruments. And he, with all this kind of a what the we have one way of one methodology when you speak about legal methodology of how we explore different the tools of research technique are different, but for an Indologist or for a historian it will be different. So his observation is that they must have used sharp instruments to clear forests, and the soil was rocky. So the whole Gangetic plain that, if you look at it, now much the forest back then itself, when people, human beings started settling down. So the entire subcontinent must have been full of thick forests, right? Then the next thing that I'd like to deal with it is that when in ancient times there were rulers who spoke about forests and about conservation of forest and how the forest resources should be exploited. And in this particular aspect, back then, what we find is that we find several different kings and rajas and maharajas speaking about protection of forests. Then the second thing is that they had to use forest, and it was used for what? For timber. And again, elephants and horses were one thing where the possession of elephants was something which is was very important for warfare. Horses is again another. Again, it is a domestic animal, but when it comes to elephants, they have to rely on the forest. So that way, they had to take care of this particular aspect. So they had to have think about what uh, how we have to utilize the forest resources was something which was very important to them. So penalties were imposed on cutting down of trees, and even to protect the wildlife, there were certain kind of things that they had to do. Then when we come to the Ashoka's famous Ashoka's edicts, I just want to take you through these slides, and I'll explain that he also had mentioned about what how you have to forbid killing of animal species, and not to burn the forest. Now, if you notice, forest burning was a problem back then, and it is a problem even now. Forest fires, the very, very we had that one recently in 2016. There was a forest fire in Uttarakhand, and it really had caused a lot of damage. And a couple of years ago, last year and 2 years ago, even in Brazil, there were forest fires. And again, who actually, what causes those forest fires? Is it something which happens spontaneously, which no one does it, and there is no human intervention? That may be a reason, or it might be people might deliberately do it. So that was a problem back then also. So there they had what imposed certain kind of what taken certain measures to deal with those aspects. Okay. Then during the medieval period also there were certain customary rights again, and I think this point I would like to raise again, bring it to your notice, that there were certain customary rights and they were acknowledged by the medieval rulers, and the villagers, those who live in the vicinity of the forest, had certain what customary rights vis-a-vis the forest. Then the famous saying about Shivaji, the Edict of 1670, he speaks at length about how you have to use the forest and for what purpose and how you have to rejuvenate it. There again, he has stated a lot about the rejuvenation of forest. And again, during the Mughal period also, there were efforts to do what? Try to impose certain kinds of taxes on using of the forest land and bringing making it a cultivable land and conversion of forest land for and using it for agricultural purposes. There again, they had to impose a certain kind of taxes, and that those taxation laws came into force, and how what they dealt with it again is one fact we have to deal with. Then after the British came into well, we were under the colonial power and we witnessed colonial power. We have to understand that the geopolitics of Great Britain. Great Britain doesn't have much forest cover, and they don't know how to handle forests and how to deal with the forest. They want forest resources all over the world. They wanted it, but they didn't have this experience of what a livid experience of forest management. And for them, forest was a commodity, and all the forest resources were mere commodity. And how and because they didn't live in the forest or in the midst of a forest. So for them, when they started colonizing or different parts of the world, what they did was they simply treated, as I had said earlier, let me, at the cost of repeating myself, they didn't have any qualms or at actually what cutting down trees and simply destroying forests. They were using this forest produce for different purposes. The timber they were using for shipbuilding and iron smelting and farming, that was one thing. Shipbuilding was one thing. Then because in any for colonies they need, and for imperialists they need what ships and warships, and they were using this whole they needed all this shipbuilding exercise they had to do. One thing is that they needed for to build warships. Other than that they wanted to to have what for seafaring again, for transportation of goods from one place to another, of mineral resources from one place to another. They needed that kind of an industry was something which was they had to feed that industry. So for that they required. And the second thing that they did was that where they needed it for railways. So if once the British came to India, they started laying railway lines all over the place. So when they were laying those for these railway sleepers, for those railway sleepers again they required what? A lot of timber. So what they did was they simply went and cut down some thousands and thousands of trees in the sub-Himalayan forests. Now, laying of railway lines was something anyone would be happy that we are connected now. Earlier, if the East India Company had to navigate, they only had the sea route. They only could use a sea route. So from Calcutta to Madras, and from Madras back to Bombay, and maybe from there to through the Middle East, they might have to go all the way from the Mediterranean Sea and go back to the country. So they were using the seafare. And the subcontinent, if they have to utilize the subcontinent, they didn't have that kind of a, so they lay those railway tracks. And that led to a lot of destruction. Then the second thing that is we have to see is that they considered destruction of forests as a symbol of political victory. So wherever they occupied a particular land, and wherever they subjugated a particular kingdom, they would simply set that particular forest on fire. That is a kind of a streak of madness which the British had. Then slowly, what they realized is that they had a kind of an urge to they realize that this forest is something not an infinite source, so they have to think about forest management, and they took the help of one German forest. We have to as I had said, we have to understand the geopolitics. If Great Britain didn't have any kind of forest cover, the Germans were what had a lot of forest cover, and Dietrich Bandis, who happened to be a forester, and they invited him, and they took his services, and the British had actually, when they started drawing the thinking about having what and having coming up with a formal law about forests, they took the help of this particular man. So the forest policy, we had the first forest policy, and he was the person whose services were taken by the British or to decide what kind of a forest policy we should have. So here, the first draft of Indian Forest Act, first attempt was made in 1865. Now, what did the law in this particular Indian Forest Act try to assert? They said that the state has a monopoly over the forest. Now, that was one thing that they wanted to establish, that it is the state which would be the owner of the property. Then the second thing is that if you make it an over, it will have they can use that forest according to their own convenience, whether they would destroy it or whether they would protect it or conserve it. See, if you the main difference between being an owner and being a trustee is that a owner has if you call a person an owner, he will have the right to either protect that particular property or destroy that property. For example, if we have this particular mobile, this belongs to me. Okay, I can use it and I can update it and maybe use certain kinds of things which will actually improve its quality, everything. At the same time, since I'm an owner of this mobile, I can also destroy it, right? So if I'm an owner. So if you say that the state is an owner of the forest and forest produce, they can use it or use it or destroy it. So they can burn it, they can do anything. So, and if you say that there are no other stakeholders, they are not accountable to anyone. People, they are not accountable to the people also. So that way, what the British tried to do is that they started saying that the British Raj has a monopoly over the forest and forest produce. This kind of exercise is something which started with the when the British started speaking about coming up with a formal law. If you notice that this was a period when codification of laws was taking place on a large scale in India. We had the Indian Evidence Act, IPC, TP, and Contracts Act, and even family laws for that matter. They tried to meddle with family laws a little bit. So this was one phase when they wanted to codify the forest laws, and there were different conflicting views which were expressed in 1865, and when this whole enactment was being dealt. One was that they felt that it was the government was the owner of the property. At another level, certain the tribal communities and the private grantees, suppose enams were there. Suppose we know that if a king or a maharaja was very happy with someone, he would simply say that, "Acha, this is a jagir. You enjoy this part. I'm giving you this part of the land. You simply use this," and jagirs, enams, different kinds of rights were given to people who were in the good books of the king. So that kind of zamindars were also given lands, and they were said that, "Acha, this part you simply use it." And this created different kinds of tenurial rights and rights vis-a-vis land, which includes use of forest and forest lands and forest produce. And till we came together and formed into a Union of India. This whole country was ruled by different set of rulers. So there were not any kind of uniform laws till the formal law which was passed by the British. So there was a conflicting view. So what when the final enactment, what it did was, they said that look at this particular Baden-Powell's statement. The right of Oriental governments in the forest passed on to and was accepted by the British government. So they started claiming that the forest belongs to, according to the Oriental governments. That is, what are the Oriental governments? The Rajas and Maharajas who were there even in the ancient times and during the medieval period and during the Mughal period, all those people, they said that they started saying that it is the Rajas who owned it, and now because we are governing this particular country, it automatically passes over to us. So what Shyam Diwan and Armin Rosenkranz in their book, which is again, I think, it is a very comprehensive way of dealing with environmental law, though it is an outdated version, and I think it is still very relevant. They said that in 1878, this this legislation, with one stroke of an executive pen, what happened is that all the customary use of forest by rural population all over the India was completely obliterated with one stroke of the executive pen. All the Adivasis lost their rights over forest and forest land and forest produce, and the Indian state became the owner of the property. And after independence, post-independence, what we notice is that earlier it was why did they use the forest and forest produce? It was used to expand the colonial legacy, and the British wanted to use it and exploit the forest produce. But when it came to independent India, now it was a state in infancy. So we had to protect the infant state. So now the 1952 forest policy was no different from the policy which was adopted by the British. Now, what were the primary concerns now? The primary concern was that we have to protect this nascent state. So the whole economy had collapsed, and we had to rebuild our economy. We had to rebuild our lives, and simply, if we have to do that, we have to go push for what industrialization, and we need big dams. We have to construct big dams. We have to think about industrialization, and if we have to think about industrialization, we have to feed those industries. And for that, we have to extract minerals. And where are the minerals? They lie under the forest. So in the 1952 forest policy also, we don't find any kind of a radical change in our perspective. It is a continuation of the kind of perspective which the British had. And now coming to what post-independence, if we have to have an understanding of the forest laws, we again have to have a constitutional, have to deal within the constitutional framework. So Article 48A and 51AG, and they speak about what the forest and about conservation of forest and protection of forest, and the fundamental duty which each citizen has to protect the natural environment, including forests. Okay, and the Constitution of India initially, when we speak about the Constitution, I have to mention this particular fact that a small country, which is our neighbor, Bhutan, has what has written down it in its own constitution that they must have this much of forest cover. So it is a constitutional mandate that they should have it 30% of forest cover, a minimum that should be the forest cover that they should have. We don't have that kind of constitutional provision in India. And if you look at Article 48A, 51AG, they were inserted much later to the 42nd Amendment. And again, if we 42nd Amendment has done what? Earlier, this was forests and forests were in the state list. Entry 19 and entry 20 of the state list. And till the 42nd Amendment was introduced, we followed the forest policy of 1952, and there was no kind of a check on the how much of what forest cover we had lost, and what happened to the forest, and how should we utilize the forest and forest resources, and whether we should think about conservation or not. We didn't have any kind of a kind of we were not gauging or measuring the how much of forest loss was there. And this realization came only after Stockholm conference. We sat back and thought, what is happening to our forest? Because that was a wake up call for the entire world. And Mrs. Indira Gandhi, the then Prime Minister, she was part of the Stockholm Conference, which took place in 1972. And her famous speech, which in which she had clearly stated that polluter is poverty is the main cause of pollution, or the poverty is the primary source of pollution. And she had actually tried to explain the predicament of the developing countries, and how we had to the developed countries were already industrialized, and they had all the benefits of getting industrialized, and we were in a very sorry state of affairs. And now it is like devil quoting the script. If they come back and say that pollution is a major issue. So this did not go well. Stockholm Conference did not go well with the developing countries. But at the same time, we lost a forest cover by 1980s. Sawmills, paper mills, and contractors all over the country, they were going and approaching the state governments, and state governments were simply granting all those contracts. And again, there was left, right, center. Then there was no indiscriminately, they started cutting down the trees. So post Stockholm Conference, and since we started looking at other countries and looking at what is happening to our own forest cover, there was again a kind of a realization. So through 42nd Amendment, what they did was they introduced they made it introduced the forest and protection of wildlife and birds, and in the they omitted the entry 19 and 20, and inserted entry 17A and 17B in the concurrent list. And I'll just go through this part, skip this particular part, because again, we have to again get into what the laws. Now that is a constitutional framework within which they had to we have to deal with the forest laws. Now coming to the laws which actually speak at length, and which we will be dealing, is the Indian Forest Act 1927. That is a pre-independence act which lays down speaks about what the first attempt at codification, then the Wildlife Protection Act 1972, then the Conservation of Forest Act 1980, and the Panchayat Extension of Scheduled Areas Act 1996, and the Scheduled Tribes and Other Traditional Forest Dwellers Recognition of Forest Rights Act 2006. Now, which is again popularly known as the FRA Act, and henceforth I will be using I'll be referring to it as FRA Act, and the Panchayat Extension and Scheduled Areas Act as PESA Act. Now, Indian Forest Act is an act where it only believes that the state is the owner of the property, not even the state. Actually, if you read that particular enactment, we feel that it is one person who is actually was empowered, and that is the forest settlement officer. And there is a famous Muria Adivasi song. And what does it say? Because again, this is a kind of a comment on the Indian Forest Act, and that is, the heaven is a forest of miles and miles of mahua trees, and hell is a forest of miles and miles of mahua trees with a forest guard in it. So that is, I mean, what happened is that, as I had said, with the passing of the Indian Forest Act, the Adivasis completely, indigenous communities completely lost their rights and entitlements over the forest land and forest cover. And they were treated as trespassers. If they had to enter into the forest, they had to take the permission of the forest settlement officers. And not only entry, if they had any claims to be settled, it was a forest settlement officer who would be settling those claims. And an appeal will lie to whom? There are forest courts or forest settlement officers, and from their appeal will lie to the state government. It will not go to a regular court of law. It will only go through the revenue department, and the state government, the district collector, district magistrate, and maybe where will it go land? How will it the judiciary be? If a person is not happy with the order passed by the forest settlement officer, or if an appeal which lies before the government, state government, maybe what will happen is that they will have to approach the High Court challenging that particular order. But there is no appeal. Direct appeal will not lie to the to any judicial officer. It's only the revenue department or the revenue courts which will be dealing with any kind of claims. So what are the kind of claims that they might have? They might have claims over the land or on forest produce. And that is one thing that we have to observe. So, but at the same time, the forest department can actually lease that for what timber, or cut down the lease it to contractors, have any kind of a agreement for what, cutting down the timber and using it for industries, sawmills, and the kind of that kind of regulation is there. They have to regulate the activity, and Indian Forest Act permits and facilitates that kind of an activity. So with this led to what? Denudation of forest on a large scale. And post 42nd Amendment, the Conservation of Forest Act had been passed. Now, in this particular aspect, what we have to notice is that the Conservation of Forest Act, Section 2, I think this is the most important provision in forest laws. It's a very tiny piece of legislation. Hardly there are it's a single digit enactment, but most powerful enactment in forest laws. And what does it say? That if any kind of no state or other authority shall make except with the prior approval of the central government, any reserved forest cannot be de-reserved, or any forest land cannot be used for non-forest purpose. And it might be any kind of forest. If any reserve forest has to be de-reserved, you have to, the state government cannot do it without the prior approval of the central government. And even using the forest for non-forest purpose. What is this for a non-forest purpose? How are we supposed to interpret it in this non-forest purpose? Again, this is $1 million question. So again, it is subject to a lot of what judiciary, it's a kind of a gold mine for all the conservationists or even those who want to interpret the way they want to. What is non-forest purpose? Is mining non-forest purpose or not? That is one interesting question we have to ask. Is what cutting down timber for sawmills, is it a non-forest purpose? Yes, obviously. So what is forest purpose and what is non-forest purpose? Now, the cultivation of tea, coffee, spices, is it again a forest purpose or non-forest purpose? Because again, there is a exemption given to cultivation of medicinal plants, coffee, spices. You must have seen that in the midst of thick forest, it is interspersed with different tea plantations and coffee plantations. How is that possible? You find that pepper, will be there. Will be twining around thick forest, dense and thick forest, and we find rubber all over the place. What I would like to impress upon the participants is that if there is any law which actually can actually stop forest denudation of forest or deforestation, if they take it very seriously, section 2 is very helpful. So in this 1980 Conservation of Forest Act had actually introduced this, and through this what happened is that now the central government also has a say. So we know as lawyers and as legal professionals that power corrupts and absolute power corrupts absolute, and we feel that there should be some kind of a division of power, and this division of power is something which will be we say that people's liberty or their right to life or personal liberty will can protect only if there is a division of power and there is no indiscriminate misuse of power. So division of power is important, and that's why we do what horizontally, vertically. We keep on what to try to do is that we want to see that somewhere or the other, power is not concentrated in a few hands. So division of power between center and state. So a federal structure in a way would had actually done what the led to slightly improvement in the forest cover. So, because if both the parties in both say state and central government, the same party is in power, maybe then there is no division of power. But if there is a different parties are in power in the state government and the central government, that division itself will lead to what people will sit back and think whether we have to cut down this forest or not. Is that particular project really viable or not? That can be done. And I think that played a major role in the Vedanta issue. If you recollect, in Orissa Mining Corporation versus MOEF, that is a case where which deals with the Vedanta issue, where in the state of Orissa, in the Kalahandi district and district and parts of it is another district in the neighboring district. There was a bauxite mine. The Vedanta wanted to take up a bauxite mining project, and already they had gone ahead with the alumina refinery project, and this landed up in trouble because the local community were against the bauxite mining, because they felt that bauxite is a kind of an ore which has a kind of water retention capacity. So it's very porous and it can retain water. So it is a source of water to many streams in that particular region. So if you start extracting bauxite from those hills, what will happen is that all the streams will go dry. So that was a major concern. The other thing is that I'm actually what they did was they relied on the FRA Act. In FRA Act, there are certain provisions where they say that clearly that the Gram Sabha, PESA Act and read with FRA Act, if any kind of a forest has to be used for non-forest purpose, they have to get a clearance under the Conservation of Forest Act as well as under the FRA Act. And PESA Act and the FRA Act clearly say that if they have to use any forest, which where the forest dwellers and the Adivasis are living, in those areas, Gram Sabhas have to be conducted, and the Gram Sabha also has to grant an approval. See, what has happened? It is the Gandhian model which we are thinking of. And what is this decentralization of power? And Gandhi believed in the Panchayat Raj system and thought that the power, it should be go to the grassroots. It should not, power should not be centralized, but should be decentralized. And every entitlement has to reach the grassroots. And I think that led to the 73rd Amendment and the 74th Amendment, where you were speaking about decentralization of power, and they gave a constitutional status to the the different the Nagar Panchayats and the Panchayat system. The PESA Act and FRA Act have gone a little bit further. And what they have done is that under that, if those particular villages fall within the 5th scheduled area of the Constitution, then if any land which is falls within 5th scheduled area, which is a forest land, then the Gram Sabhas have to decide and approve if it has to be used for non-forest produce. I think the Vedanta example is the best example, where what happened is that there was a difference of opinion between the central government and the state government. So in terms of Section 2, what happened is that in the center, and I know law and politics go together. We can't simply discuss about law without speaking about politics. That is the way I look at things. Maybe there may be another way of looking at it, but the what happened is that the then government which was in power, that was a Congress government was in power, and in the Orissa we had the Navin Patnaik government. So they had their different political parties were in power. What happened is that Orissa government was in favor of the Vedanta project. They wanted to go ahead with that particular project, whereas the central government, somehow what happened in this whole what led to their taking that particular decision was that they said they opposed the Vedanta, and they cancelled the clearance which was given, environmental clearance which was given to the bauxite mining project, and they said the entire deal was cancelled. So what what Orissa Mining Corporation did was they went took that matter to the Supreme Court. That is how the Orissa Mining Corporation versus MOEF. So what is it again? Both of them are at loggerheads. And they challenged this move of the central government, MOEF, to cancel that environmental clearance. So look at the beauty of this particular case. Now, so many institutions are involved. State government, central government, and even the judiciary. What Supreme Court had to do is that one of the issues was whether Section 2, whether prior approval is required or not. That is one thing. Then whether environmental clearance given under the environmental impact assessment regulation, did they follow or not? That was one thing. Then whether they had violated the norms laid down in the FRA Act, that was another issue which had to be raised. Regarding the other issues, it was keeping that aside. When the Supreme Court had looked into the fact whether there was a violation of the Forest Rights Act, it came to the notice of the court that there was no, Gram Sabhas had not cleared this particular matter. Okay. So the Supreme Court said that then in that case, take that the whole, you place it before the Gram Sabha and see whether they approve this conversion of they approve this particular project for non-forest produce, quote unquote non-forest produce. Will it be allowed or not? Should it be allowed or not? So what happened is that the Orissa government had to conduct gram sabhas in all the villages which were supposed to be under the spell of the bauxite mining project, Vedanta's bauxite mining project, and many hundreds of villages fell into the purview of that particular project. So what the Supreme Court have was, and Orissa government had to do was that now you can't conduct a gram sabha in those all the 100 gram villages. So they said that you pick and choose a few and select a few and based on that you conduct what a kind of a create a sample obviously, and out of that select a few villages and conduct the gram sabha. So the Orissa government selected the certain villages, and in the presence of district judicial officers, the district judges, and the entire gram sabhas were recorded back then. In their presence, what they did was they conducted the gram sabha. In one gram sabha after another, one gram sabha after another, they started saying no to the Vedanta project. Why were they so concerned? Why were these, they were the Dongriya Koons. Why were these Dongriya Koons concerned about the cutting down of the forest and about this particular project? Because they considered that particular bauxite, the hill, as Niyam Raja. So Niyam Raja means what? He is Niyam. Niyam is rule. So he is our god. The Dongar means the hill. So they consider the Dongar as the Niyam Raja. And since he is a god, it will be very, very difficult for us to say that you cut down you extract minerals from that particular hill. So the Gram Sabhas, all the Gram Sabhas unanimously said, passed a resolution against that particular project. So now with all these resolutions which were passed by the Gram Sabha, the matter went back to the Supreme Court. And what did the Supreme Court say here? The law says that the resolution has to be passed by the Gram Sabha. And the Gram Sabhas have passed a resolution against the project. So our hands are tied. What can we do? We have to go by what the Gram Sabha tell us. So it's an amazing kind of a decision where they say that ultimately they say that it is the people of that particular region who are supposed to decide. And neither the central government nor the state government, and finally the Supreme Court, what did it say? Since it is a resolution passed by the Gram Sabha, we cannot interfere in their decision and we have to respect their decision. And based on that, the whole project was stopped. And I think it is a kind of what I cite this particular case and I bring it to you. I must have discussed it in some other context. But this is a kind of a case where you get to know about the Conservation of Forest Act 1980 and the importance and significance of Section 2, how significant it is. Second thing, we get to know about the PESA Act and the FRA Act and how things have changed. There is a kind of a paradigm shift. Under the Indian Forest Act, how were the Adivasis treated as? They were treated as trespassers. Then by 1980, the central government, it got a little bit from the state government. The central government also had a say in matters related to forest and forest cover. Then later in the 1980s, they started thinking that we should not treat these Adivasis and the villagers living in the vicinity of the forest as foes, but as friends. And joint forest management, JFM programs were taken up, and social forestry, they entrusted it to villagers. Taking care of forests, they started taking the forest dwellers into confidence and saying that you are part of the forest and you have And they started saying that it is you and with your help that we are going to protect the forest. And the preamble of the Forest Conservation Act, if you notice, speaks about what it says, where that a historical injustice had been done to the forest dwellers, and this particular enactment is going to be passed to address that historical injustice. That is the kind of what um, uh, change that we took place in how the Indian state started looking at forest, and how it started looking at the people who will be helping the strengthening their hands in conservation of forest, who will be strengthening their hands. They started realizing that the scheduled tribes and the other forest traditional forest dwellers are what we have actually marginalized them and pushed them into what chill penury, and we have to address this whole issue of the kind of historical injustice which had been met with, and treat them as what part of the entire exercise of conservation of forests. Okay. And before what there are many, as I had said, entry points in discussing about the forest and forest laws. And I think one major, it will be completely incomplete. This discussion would be completely incomplete if we don't mention the Godavarman and who is this man who had spoken or dealt with the whole issue related to what this I'll call it, I coined the term Godavarman jurisprudence, because if you look at it, this was a man who was a erstwhile Raja, and he, as we know, the then zamindars and rajas had to give up their lands and their rights over forest and forest land. So the ancestral, the forest which belonged to the ancestors, it was handed over to the Indian state. And one day when he went and visited his own erstwhile forest land, he noticed that they had cut down forest the trees, and it was in a sorry state of affairs. And he was really very unhappy. So he approached the Supreme Court. We had so many cases which speak about conservation of forest. This is one way, what this is a what conservationist kind of an approach. Now, when we speak about the Forest Rights Act and PESA Act, that is again, what is it again? It speaks about how you have to, in the whole pursuit of protection and conservation of forests, we have to think as consider Adivasis and forest dwellers as the stakeholders, as what part of the forest. They have a symbiotic relation with the forest, and you cannot try to alienate them from the forest, and they should be used in what the whole idea of conservation of forest will only take place and will only materialize if we include them as treat them as friends of the forest and take their services, utilize their services. That is one approach. When you come to the Godavarman case, this is a case where they deal with how industrialization, rapid industrialization and mineral mining was causing a lot of damage to the forest. So the Supreme Court, it led to what a lot of judicial activism, and Supreme Court took the role of what it constituted committees, and those committees would go and try to look into the management of the forest. They lost confidence in the forest department, which were and when they lost that confidence, what the court did was, in this particular case, it entrusted the work to committees to look into what see how many trees were cut down, and if they have felled the trees, what had create an inventory of those trees, and if the trees which were felled were rotting, after creating the inventory, they had to be sold. and that also how that sale process, how their sale has to be carried out. The Supreme that monitoring committee constituted by the Supreme Court was looking into it, and they were deciding how much, what should be the price, everything, and how that sale has to be done, and through where, what are the, how are they supposed to be transported from the forest area. So that is the kind of what kind of a rigorous exercise which the Supreme Court had taken up in the name of Godavarman, Tirmalpad versus Union of India. Still, that whole thing is continuing. Godavarman passed away, but his case, his legacy continues in the Supreme Court, and now, even now, we find that several cases, it's the main case is still pending. There are several interim orders being passed day after day, and we have what a kind of so many Godavarman interim orders, which actually try to see what speak about conservation of forests. And one interesting thing that happened in this whole thing is that we are we are almost I'm almost about to conclude this session, right? And we didn't speak about, we are speaking about forest and who owns the forest and the rights of the forest dwellers and Adivasis, but we didn't speak about the definition of forest till now. And strangely, we don't have a definition of forest either under Indian Forest Act, nor does the Conservation of Forest Act define forest, nor does PESA Act or the FRA Act speak of the definition of forest. Forest land, yes. What do they speak about forest land? Any law which is what notified as a reserved forest or a village forest, or as a protected forest, is treated as forest. I mean, whatever, which area which is notified by the state government as forest is forest. So suppose in the midst of, suppose MP Law College is in the midst of Aurangabad. If the state government of Maharashtra wants to notify the land on which the MP Law College is situated as forest land, then that can be treated as forest land. If we go by the definition of forest land under the Indian Forest Act or Conservation of Forest Act, so even it depends on the order passed or the notification issued by the state government. Actually, what happens is that we hardly realize when we are traveling in a particular place that we are passing through a reserved forest, because when we speak about forest, we have what in our mind we assume or we presume that as a forest means thick, dense forest. That is not the case. So, what is forest and what is forest land? Again, it was left to the Supreme Court to define, and they said that you have to go by the the definition simply says that we have to follow the the dictionary meaning. Whatever the definition is like given by the dictionary, that should be treated as forest. And the I would have, it would have been ideal to discuss even the Samata judgment, but I think we are running out of time. How much time do I have, Lokesh? Should I stop, or because I have to give a?
And there are certain questions that are posted in the Dropbox.
Okay.
So if we could summarize the things, that would be much better.
So I think I'll conclude. Before conclusion, Orissa Mining Corporation case, Vedanta case is one thing which says that it is the Gram Sabhas which have to decide. Then when it comes to I think Wildlife First versus MOEF, which was decided by the Supreme Court in 2019, February 2019. We are back to square one again. Okay. Under FRA Act, And what does it say? That it is the Adivasis are part of the entire exercise of conservation of forests. In wildlife first case, what they this is a what hardline conservationists, wildlife first, the petitioners. What they did was they said that under the FRA Act, many people, petitioners, those who could not be granted forest rights over forest lands, they should be evicted. And Supreme Court in its order passed in February 2019 said that past eviction gave directions to allowed that petition and gave orders to evict those Adivasis. If if that order was implemented, almost 20 lakh Adivasis would have been evicted from their natural habitat. So wherever they were residing, they would have been evicted. There was a big hue and cry against that particular order, and immediately Supreme Court again had to review their decision and they put it under court. That is one major development. So now where are we in terms of what back and forth I was talking about, the perpendicular conservationist and anthropocentric laws, those who believe in that approach. That is one kind of, so we are getting back to where we are saying that Adivasis should not have a say in matters related to forests, and they should not be considered as friends. And again, there was an attempt at revamping the Indian Forest Act in 2019. That is a bill, draft bill. And this draft bill was worse than the 1927 Indian Forest Act in terms of what they were already the Adivasis were completely disempowered. This particular act actually further disempowered. So whatever ground which was gained through the FRA Act, that was also completely they tried to take it. So that is the kind of a seesaw kind of a thing which is happening in the name of forest and for forest conservation. And I know this is both these groups are very, very polarized. And this polarization is what happens in such a way that, and it's where people are very, very emotionally believe in the way we have, it is divided in terms of a discussion on death penalty. People are polarized. Reservation, they are polarized, and they take it personally also. Similarly, this debate between conservationists and anthropocentric people who believe in anthropocentric laws, there is a great divide. And these things are what leading to different kinds of assertions in the court of law. And we are getting conflicting judgments. Some go in favor of conservation and some speak about protection of forest dwellers, and that understand the symbiotic relation between them, and try to speak about what the issues of man versus wildlife, and then again forest versus industry, and forest versus mining. So we have different things which are happening in that particular area. And I think after I'll conclude this my lecture here and look at what the issues which have been raised in the wait a minute.
Okay. Thank
Yes.
you.
Please, Lokesh, I'm not able to locate the chat. Can you please take me
I'll read
through
it out to you, ma'am. We have first question from Mr. Shukre. He says, do you think that the category strategic importance created by a Subramaniam committee report is violative and vague, as it is more like anybody's guess? Question comes to mind because Mohan Forest in MP, the villages there were forced to leave in the light of prerequisite consent. The said report was being criticized because of its approach and missing the forest, etc.
Can you just repeat the question once?
Yes, ma'am.
I missed the first part.
Yes, ma'am. He goes like, do you think that the category of strategic importance created by Subramaniam committee report is violative and vague, as it is more like anybody's guess. Question comes to mind because Mohan Forest in MP, as villagers from the forest were forced to leave in the light of prerequisite consent. The said report was being criticized because of its approach and missing the forest, etc.
Yes, I think I didn't include the discussion on Subramanian committee report because I think when it came to law reform, this committee report, though they had a discussion on it, elaborate discussion on it, but somehow it did not become a part of a formal law. So I didn't deal with that part at length. But as you have rightly pointed in your question itself, the answer lies.
Okay. Thank you, ma'am. We have one more question. It says, well, we have two more questions. One is, what is the future of ancient Indian fort, forest, and some ancient Indian rivers like Ganga, Jamuna, Saraswati? In Mahabharata, okay. He says, in Mahabharata, Lord Krishna starts the Govardhan's worship. Don't you think that it's time to change something like that in all over the world?
Obviously, anything comes, good initiative from history or from epics or from mythology. If they speak about conservation of forest, why not? We have to learn from everything, from history, from our neighbors, from maybe some other parts of the globe. If some good initiative comes, suppose we are speaking about and big the whole big dam Narmada Bachao Andolan. We started that whole project, that Andolan, because we had picked up the cue from the big dam movements which started in Brazil. So we don't know, something good coming from any part of the world, it is appreciated. And from past, something from the past, if there's something good, why not? Definitely. We have to. That's why I wanted that kind of historical perspective we should have. That's why I started in the ancient history part.
Okay. Very true, ma'am. That is, I think that's all for the queries sections from the attendees. There's notice for, thank you, ma'am, for satisfying the questions that were posted. To all the attendees, there's a feedback form link dropped in the chat box. Please take a few minutes and fill it. Now, I request this lecture series and IQAC coordinator, Dr. Aparna Kottapalle, ma'am, to present the vote of thanks.
First, just before concluding, I'd like to thank once again for inviting me. Both the college as well as Dr. Aparna and more than anyone else, Dr. C.M. Ravi.
Thank you, ma'am. Thank you, ma'am. Thank you, Lokesh, for giving me this opportunity. I am much thankful for today's session to Dr. Sudha, ma'am, who not only enlightened all of us on the forest law, but what kind of symbiotic relationship that exists with the forest, the human being, or the tribal community people. Generally, when we talk about the forests, people forget to discuss the issues about the tribal community people, and that actually was the essence of our discussion or the discourse in today's session. We are much thankful to you, ma'am, for that. And actually, we would have loved you listening more, but due to time constraints, maybe you had to wind up the discourse. But of course, with the permission of principal, I would like to request you on behalf of college that maybe in future also we will be having the same kind of linkage wherein you would be guiding our students. So let me take this opportunity to thank you for accepting our invitation and enlightening all of us. I am thankful to Dr. C.M. Rao, Sir, Principal, MP Law College, for continuously supporting this environmental law lecture series, all lecture series, and for his constant support and guidance. I am thankful to Professor Mr. S.N. More, who is Vice Principal of our college, for delivering the welcome address. I am thankful to all the participants on this Zoom platform, as well as who are witnessing this academic endeavor on YouTube Live. I'm thankful to Lokesh for conducting this session very nicely, and for all the attendees for being interactive through the question answer sessions which you had placed in the chat box. Again, before stopping for today, I would like to remind you all that please give your feedback. That would certainly help us in improving ourselves and to understand what all are the weaknesses from the side of the host, so that we would be able to improve. Once again, I thank you all. I thank the organizers for giving me this opportunity to propose vote of thanks. Remind you all about tomorrow's session, that would be on environmental impact assessment process and public participation in it. Thank you, one and all. Thank you, ma'am. With the permission of chair, now I declare this session is over. Thank you, ma'am.